Learn easy and smart. English dictation. PDF of this dictation will be available in description. If you are new to our channel, subscribe this channel and click the bell icon so that you can get notifications for all uploads. Dictation start. It appears that after all such futile attempts, the appellants did not give up their pursuits to get allotment of sal seeds from the government. In 1986, both the appellants filed two separate but identical writ petitions, being MP number 645 and 644 of 1996, challenging the reservation and allotment of 10,000 metric ton of sal seeds in favor of Messrs. MP Glycem Industries, which was also selected under 1977 industrial policy. Such writ petitions were also dismissed by the High Court by order dated 6/5/1986. Thereafter, the writ petitions were again filed by both the appellants challenging the renewal of lease in favor of the respondents Messrs. Bastar Oil Mills and Messrs. Sal Udyog Private Limited by treating such renewals as new leases and also challenging the determination of royalty to be paid for the sal seeds to be supplied to the respondents. Such writ petitions have also been dismissed by the division bench of Madhya Pradesh High Court, and the present appeals are directed against the decision of the High Court passed in the said writ petitions. Mr. Sanghi has further contended that there is no earthly reason to be completely oblivious of the needs of other industrial units operating in the state, which also require sal seeds for their units. The need of old units was recognized by this honorable court when when it directed the state government to allot 5,000 metric ton to both the appellants by interim order dated 6/5/1982. The appeals were disposed of by this court on 10/4/1986, and the matters were remanded to MP High Court for determining the basis of distribution of sal seeds among the old units. On remand, the High Court by order dated 18/10/89 held that the surplus would be distributed among old units on the basis of their capacity. In order to perpetuate the hostile discrimination, the state government entered into fresh agreements, thereby ensuring that there would be no surplus to be distributed to old units like the appellants. In the instant case, the state government of MP framed industrial policy in 1979 and thereafter revised the same from time to time according to felt need. There is no material on record from which it can be reasonably found that the same was not informed by any reason whatsoever that apart such policy has been taken into consideration by the High Court of MP and also by this court in the earlier proceedings and the industrial policy has not been found to be arbitrary or capricious. On the contrary, the agreement made in favor of the appellants was struck down struck down by the High Court by indicating that unlike other class of industrial units like the respondents Bastar Oil Mills and Sal Udyog Private Limited, which were entitled to special treatment under the industrial policy, the appellants were not entitled to any special treatment which was not given to other existing old industrial units in the state. Similarly, circumstanced so far as the contention that royalty for the sal seed to be supplied to the respondents has been fixed unreasonably in order to ensure naked favoritism to the said respondents is concerned, the appellants have failed to demonstrate such naked favoritism. The fixation of rate of royalty on the basis of weighted average formula has a rational basis and is also a known method and modality for determining market price. It also appears to us that the price per metric ton of sal seed has different components of which collection charges is the principal factor. It may also be noted here that the revisions of royalty by the state government at rupees 750, rupees 1030 and rupees 1030 per metric ton respectively for 83 to 85, 85 to 87 and 87 to 89 blocks had been challenged and such revisions were struck down by the High Court of MP and the High Court directed redetermination of the rates of royalty as per the established weighted average formula. Arbitration was held for determining the appropriate royalty and the royalty thereafter was refixed at rupees 300 per metric ton in place of rupees 750 rupees 300 per metric ton in place of rupees 1030 and rupees 294 per metric ton in place of rupees 1030 for the said three blocks. In the aforesaid facts, it cannot be held that the fixation of royalty in the impugned agreements is without any basis and wholly arbitrary and designed only to ensure favoritism as alleged if there is an objective and rational foundation for the fixation of royalty, the court will not interfere with the exercise of governmental decision by itself undertaking an exercise to find out as to whether better fixation was possible or not. It needs to be noted that in matters of economic rights and policy decision, the scope of judicial review is limited and circumscribed. It may also be indicated here that within the ambit of protective measure of assured supply of sal seeds, such supply at concessional price is also a relevant consideration. The state government may not be dictated by the only consideration of more revenue. Stop. धन्यवाद.